Hey guys, and welcome to the Working Money Channel. So it looks like June 13th has come and went, another anticipated day that came and went without any real effect on the XRP market or price. Well, yesterday, as you guys know, we did see the Hinman emails. That was kind of the biggest news yesterday in crypto. And, we can see the price did move up temporarily, but there was a quick sell-off right after, and we actually came down lower, believe it or not, ironically lower than where we began. So XRP right now trading just under 50.5 cents. And, these are the things that are very difficult to predict because, you assume, okay, maybe we'll be getting good information from these emails and that could send XRP price up to higher highs. But alas, we got those emails, and I know some people in the XRP community felt a little underwhelmed. But what can we glean from the emails, guys? Was there more than meets the eye? I'm going to talk a little bit about that now that it has been a full 24 hours, give or take, since the Hinman emails have been released. It's given us some time to digest them. Let's take a look at the market though first. So XRP sitting at about 50.5. We've got Bitcoin trading right down in here. So it's down a little bit, 25.9, but really just kind of chopping sideways. We haven't really seen too much momentum for either of the top cryptocurrencies. Bitcoin, again, not too much movement, not too much volume, but the overall outlook still making higher lows and higher highs. So that is a positive thing. And I take a look at it and saying, no, it's more than just status quo. It is actually good because, when you take a look at it this way, with all the negative news coming out, with all the exchanges being sued, we are still seeing a relatively stable crypto market. We aren't seeing wild swings. Well, maybe for some cryptocurrencies like ADA, because they were specifically called out by the SEC, but by and large, most of the cryptocurrencies are still moving in the same kind of way. We got the total market up here as well, still making those higher lows. And hopefully we're going to continue to see some higher highs here. So market is moving, well, pretty much status quo. And XRP trading at 50.5 cents. So what is next, guys? What can we glean from the Hinman emails? Was it a big nothing burger? Or is there more than meets the eye? We now need to hodl until the next big date. I fear this court case will go the distance and the losing side will file an appeal and we will have 2 more years in court. Now that is the worst case scenario, but it's still not actually that bad considering what could have happened. And we're just lucky that the Hinman emails were released and they did contain the information that, we pretty much called it. So wanted to thank XRP Venture here just for posting that. Now, lots with regards to cryptocurrency news was coming out yesterday. Tom Emmer retweeting out Gary Gensler. There's nothing about the crypto securities market that suggests that investors and issuers are less deserving of the protections of our securities laws. Congress could have said in the 1930s that the securities laws applied only to stocks and bonds. And for more, read my remarks. Tom Emmer retweeted out Gary Gensler's remark. The community note, my bill, the Securities Clarity Act, would resolve this debate. But I found it funny that Twitter actually thought that people might need more context to what Gary Gensler is saying. It is important to note that the application of the Howey test to cryptocurrencies and digital assets is still a topic of debate and ongoing regulatory scrutiny. Furthermore, the SEC does not have unilateral power to declare anything they wish a security. Good on you, Elon. Brad Garlinghouse did come out yesterday also with his opinion on the Hinman emails, and Stuart Alderati actually posted this little video here that I guess Ripple's legal team created. It's absolutely unconscionable that a regulator, when presented with so much pushback on what he was about to say / how he compiled this fake test in the first place, decided to move forward anyway and throw an entire industry in chaos. For the SEC to sue Chris Larson and me personally for allegedly selling unregistered securities when their own division had deliberately created confusion about this, well, I don't have a single polite word to describe this deplorable, politically motivated overreach. Seeing the depth to which the SEC has essentially weaponized the lack of regulatory clarity through enforcement action since this speech was given, it's no surprise that we can call bluff on their claims to just come in and register as nothing but bad faith. So, it's no surprise Brad Garlinghouse's sentiments on this have remained consistent. This coming from Gabriel Shapiro here. Whatever you think of Hinman's emails and Ripple's chances of winning or losing, I think we can all agree that the SEC policy, tactics, everything in crypto has been an absolute mess. And I tend to agree with that. They could have approached it better, but here's where we are. We know ETHgate now is more of a reality than ever. Well, the proof is in the pudding. The proof is in the Hinman emails, really. Even before Gensler, though, inviting arbitrary application of law through nebulous morphing non-guidance We cannot have arcane priests going token by token through elaborate analyses of facts and circumstances, deciding these issues every time. We need Congress to step up and create a clear, reasonable, easily navigated set of fit-for-purpose rules for crypto. Even within this set of documents, you have trading and markets cheering on that Hinman will clarify that ETH is not subject to the 1933 Act, but then seemingly imply that there could still be Exchange Act issues, i.e., with regards to Ethereum. This makes absolutely no sense at all. Okay, so I think it is pretty clear, and I have a feeling everybody other than the SEC now and maybe a few Democratic supporters now can see how corrupt this has been. I guess the question now remains, will they do anything about it? Will it get swept under the rug? What will happen next? How much power is there on the right side of the aisle to make a change? So what else have the Hinman emails brought forth, either directly or indirectly? Wrath of Kahneman here saying this: the irony is nothing has changed with the release of the Hinman emails. I don't know if I believe that. The public just knows what's being considered, but we already knew the gist. Okay, I do agree with that statement. Good, yes, but nothing new, he says. Interesting Ripple is trying it in the court of public opinion. What's the role of political pressure here? And Aldo here just responds, exactly. This is just confirmation of what we already knew. This just proved of the grand conspiracy that was very clearly real, but we've just scratched the tip of the iceberg. Now let's see how deep our new friends, Charles Koff, can dive. He's busy defending it to Brad, says Wrath of Kahneman here. Clano 101 saying, to be honest, it makes the situation a little bit worse. We now have confirmed all our suspicions, but as you correctly pointed out, this info has always been available through the courts. Disheartening to know, but the court still seems ultra reluctant to make a decision. Wrath of Kahneman responding, yeah, but I don't see how it makes anything worse, other than disappointing folks who hoped for something groundbreaking, and there's just no evidence to assume we know anything about the judge's feelings or perspective. So now it comes around to Judge Torres, which gets us into the next step of the case. And, I personally believe that the Hinman emails will help the sentiment move in the right direction, not just for the XRP community, obviously, but I think for more people involved. Now that we know, now that more people are aware of how corrupt the SEC is, because, we got to remember, in the XRP community, we have always thought it for years now, but maybe there were questions being asked, throughout the rest of the industry and even through lawmakers, maybe in Congress. So now that that is exposed, what is the next step? People are constantly asking me when this case will be over and what is next. This coming from Crypto Insight here on Twitter. The next step, guys, is summary judgment. So this is now the next date that the XRP community will be focused on. For this, Judge Torres has to tread so carefully with the answer. She has thousands of documents to take into consideration and around 100,000 XRP holders via John Deaton. Anything she says in this ruling will be scrutinized to the nth degree and possibly manipulated by either or both parties if there is even a fraction of possibility to do so. Not only this, the Ripple versus SEC case is being deemed the biggest non-fraud litigation in the US since the introduction of the Howey test. Her decision will most probably be quoted in any and all lawsuits regarding crypto in the USA for the foreseeable future. So that puts a lot of pressure on Judge Torres. Torres has to get this decision right. Yeah, I don't doubt it. I would prefer her taking her time and delivering a watertight ruling, however she decides, than a vague, unclear decision. So wouldn't that be the worst? If after all this, she still gave a lukewarm, unclear decision, as Crypto Insight UK puts it here. The pressure is really on her. As I mentioned above, 100,000 of the general public fighting the agency who claim to protect their best interests puts an extremely interesting dynamic on this case. A final point, Torres' decision is essentially going to decide the future of Web3 in the United States, at least in the short term until Congress gets their act together, which realistically probably won't be until after the next election. So there's that point on it as well. We will get judgment, it's just a matter of when. For that, I cannot answer, but I feel like it's coming soon. I personally believe secondary sales of XRP will be deemed a non-security. I'm no lawyer, but not only does this seem like a technically logical decision, but it also takes the pressure off the case and the judge. It would allow the trading of XRP to resume on exchanges in the United States, whilst removing the consideration for the 100,000 retail XRP holders from future decisions. So that seems logical, I think. Why put secondary sales into question? It just doesn't make sense at this point, especially, from now, what we know from all the information that we've been given. This case could then be taken to trial, and initially primary sales of the asset could be discussed in depth. With all this being said, I'm on the edge of my seat, Judge Torres. I eagerly await your decision. Let's see if the future of crypto will reside in the United States or whether innovation will continue to move offshore. Very good sum up here from Crypto Insight UK on Twitter. So what else did we get, guys? Jungle Inc. here mentioning this. In some ways, the Hinman docs were more powerful than expected. The SEC acknowledged that Hinman was making up his own tests, not based on the law. They also admit this creates confusion. SEC admits if someone is using a token, it's not a security, so that's a very good point. This is good for ODL, which, again, ODL, one of Ripple's primary focuses right now. The SEC admits they are not even sure on Ethereum and may want to change their stance in the future. The SEC admits there are regulator gaps that they may not have authority over. So all the things that we have been saying, they admitted in those Hinman documents, and they were too scared to release because, well, we told you so. The SEC listed the Hinman speech on their website to guide the market. Clayton personally directed market participants to this speech. The whole crypto space shifted to be compliant with his guidelines. If the SEC wants to shift policy, do so with further guidance, not enforcement. So, I mean, that makes logical sense, but clearly they want to maintain a stranglehold on the industry. I also wanted to share with you this tweet thread from Adam Cochran, okay? SEC Hinman email release summary, not a big impact to the XRP case. Decently positive for Ethereum, he says. Nuance puts Gensler in a corner. Let's recap the Hinman speech and I'll explain why this is damning for Gensler's position. So, Hinman's guidance in his speech certainly went beyond the scope of Howey by attempting to understand the nuanced intent of users versus investors, as well as trying to ask the question of morphing this concept of can something be a security and then later not a security, which caveat I think can derive from the Howey itself, but that's another thread. But Hinman was so focused on the idea of morphing that he wanted that to be the initial name of the speech. So we got information on that yesterday. The feedback comment from the SEC staff specifically noted to him that they wanted to pivot to a discussion of what is a security rather than the idea of morphing, and that their concerns came from implication differences between the Securities Act and the Exchange Act. And Adam here posts a bunch of screen grabs just for supporting material. If you guys want to read those, I will link this in the description. Hinman specifically drew attention to the idea that promoters has a very specific legal analysis point, and that even a coordinated group of actors working on something wouldn't rise to the level of being deemed the promoter if their efforts weren't essential. Then Hinman points something Gensler has seemingly forgotten. In Howey, Orange Groves did not become a security even though the sale of the future profits of those were. Okay, moving down here, the digital assets itself is simply code. It is the way it's sold, an investment contract that can be a security. Then we have the draft Ethereum piece, where after meeting with Vitalik and his lawyers, Hinman held the view that Ethereum was not at such time a security, and the secondary sales didn't raise Security Act concerns, only Exchange Act and Commodity Act concerns. That footnote is of incredible importance, as it notes that the SEC at the time internally viewed secondary sales not as sales of the promoter. Keep this in mind as it's important once we get to proof of stake. Another interesting point from the SEC notes that actually the more challenging analysis related to BTC. Well, they didn't want to call BTC a security. A large part of their analysis on why Ethereum isn't a security was its practical use as gas, which BTC lacked. So that's an interesting point there. SEC internal staff were concerned that taking a position in the speech would not be the right approach, something that Gensler has no trouble doing on CNBC, and suggested that formal statements could be made separately, although they never were. Hinman highlights that something having utility doesn't make the sale of it not a security, but once again highlights the non-transitive property of an investment contract. The presence of an IC does not make the underlying commodity a security, only its sale. Now to some of my favorite parts. Hinman gave a list of the questions one could ask about digital assets to determine if something is or is not a security, and the SEC staff gave feedback to that. Some of these Gensler leans on today unfairly. Hinman asked, did a group retain a stake they expect to go up in value? And the SEC bluntly asked, how would this apply? Pointing to the fact that this isn't even really relevant in the Howey analysis. SEC staff also didn't blanket agree with ideas that asset distribution mattered, nor that anyone could make a determination about the purchaser's intent to making a purchase. Finally, the SEC staff pointed out it is not the existence of a secondary market, but the efforts of the promoter to promote the secondary market that matters in the secondary sales analysis. So where does this leave us? With really just the statement that Ethereum, as currently offered, is not a security, isn't exactly a smoking gun. So why did the current SEC want to block it so badly? Because it paints them into a corner. And this is an interesting point. The Ethereum sticking point, I think, is what they really wanted to avoid, considering all the backdoor dealings that, that we've uncovered as the XRP community that clearly do exist. There's the Vitalik Buterin conversation too that I mentioned in yesterday's video, which if you guys didn't catch yesterday's initial video, I will link it up here in the top right-hand corner. The SEC knows that the morphing argument has some quasi-valid grounds because of the non-transitive property of an IC to the underlying asset. So something could start as a security and become not one, which is what Gary hates. However, if the SEC wanted to argue that Ethereum is a security today, the release of this document shows that at one point in time, they thought it wasn't, meaning they all acknowledge the reverse morphing of an asset becoming a security. Even worse, they are doing that upon secondary sales, as the Ethereum Foundation is no longer selling Ethereum to you directly in an offering and is not the fundamental developer of Ethereum. If the SEC wanted to make that case, they must first acknowledge the idea of morphing. Second, prove the burden of a promoter being liable for all secondary sales of an asset ever. And 3, break every precedent of horizontal and vertical commonality. For Gary to conclude that proof of stake Ethereum is a security, he would both need to fight a landslide of precedent on the most litigated part of the Howey analysis and admit to the idea that security status can change over time with decentralization, and that is not what Gary Gensler wants to do. It may not seem like there's a smoking gun here, and there certainly wasn't one for Ripple, and I think that's what the XRP community was focused on specifically. We wanted that smoking gun for XRP, but broadly, guys, I think this does give a lot to the crypto market. It does now support a lot of these other projects and a lot of the other lawsuits that are now happening. What it really does is delegitimize the SEC to no end, which I think is ultimately the best for the entire crypto space. He says here, but then I think Ripple's lawyers knew what lay in the nuance, and they just threw this entire industry a bone. And for that, I applaud them. So which is it, Chairman? Can securities status morph over time with decentralization, or is securities analysis immutable with commonality only bound by the primary sale of the promotion of the secondary sale? You got to pick one. You cannot pick two. So a great, lengthy but informative tweet thread here by Adam Cochran. I wanted to thank him for that, really giving us, a good sense of both sides of this equation. For the XRP community, maybe we're thinking, okay, we were hoping for something bigger. We were hoping for, big price activity. We did not see that. We did see it briefly, but then, of course, price came right back down again, hovering at 50.5 cents. Nevertheless, guys, this is ultimately good for the longer game. Fred Rispoli here saying he's out in the field right now for work, and we'll elaborate later. But for everyone that is underwhelmed at the Hinman emails, remember to use your higher order thinking skills. This is only what we have for this case. So again, talking about the broader spectrum, not just Ripple and XRP, but the broader spectrum, delegitimizing the SEC, I think is the name of this game, the theme here. There is so much more that a congressional investigation and other cases can dig for now. For example, think of what happened after the speech. You think no one asked Bill, WTF? You ignore everything we said. Tip of the iceberg indeed, and the credibility of the SEC is shot in the Ripple case, even if it's easier in hindsight to see why rulings have been breaking for Ripple since Judge Netburn and Judge Torres read the emails, and both now the implications of what else likely exists, even though that type of speculation will never appear in an order. So yeah, I mean, the judges, Netburn and Torres, are also now going to, see, I guess they already knew the contents of the emails, but this puts a whole other layer on, because I bet you they are gauging Congress's sentiment, the public sentiment, crypto Twitter's sentiment, the industry sentiment, everything, right? And they got to be very, very careful to make a decision that, has clout moving forward. So a lot is on the table here. And I think, as Fred Rispoli said, as I mentioned earlier, this is big. This might not be good. I mean, it's not bad. It wasn't maybe what we were expecting in the XRP community, but guys, overall, this is great. Pro Crypto Frecky here bringing this up. So this was apparently released. This was filed just yesterday, as you guys can see up here, June the 13th, 2023. Again, taken from the analysis from April of 2019. And here he highlights this part here, an analysis of the above based on the above analysis and subject to the qualifications and assumptions set forth herein. We believe, as of the date of this memorandum, that you have reasonable grounds to conclude that XRP does not satisfy all elements of the Howey analysis and is therefore not a security for purposes of the federal securities laws. So that was a determination that was made back in 2019, and this document was filed again just yesterday. Some people here wondering what it is, like Anders here, where is this from? And it looks like, pretty sure it's a reference opinion from a third-party company, not the view of the SEC itself. So again, they got outside help, outside references, to kind of help them along the way to determine what was what, yet they did not listen. And of course, this just goes to the smoking gun that they were trying to hide something else, namely ETHgate. Some positive feelings here, though. Jeremy Hogan, we all got feelings about the Hinman emails today, but don't forget that Binance filed its brief today, and look what agreement and look at what argument it raised. Number one, the Ripple on investment contract requires a contract, aka the blue sky defense. So guys, we've also got the Binance situation that is kind of taking a back seat. I'm going to be talking about that a little bit later this afternoon. So to sum it up, guys, I think we just have to remember this, just in case you think this unsealed documents are a nothing burger. This coming from Ashley Prosper here on Twitter. Number one, Ethereum free pass confirmed. Number two, regulatory capture confirmed. Number three, Hinman ethics breach confirmed. Number four, market confusion confirmed. Number five, SEC overreach with Howey analysis confirmed. And number six, Ripple's fair notice defense is affirmed. If that's a nothing burger, I'll take 100 more, please. Ashley, I couldn't have said it better myself. That's also my opinion, but I want to hear what you guys think. Please subscribe to the channel if you haven't already. Like the video if you like the content I'm providing. I always love hearing your comments. See you in the next one, guys.